In terms of business income in general, do you feel like a spouse actually can hide income through a business?
I mean, I feel like a lot of times.
Welcome to the Family Law Insider. My name is Katie VanDeusen. I'm the managing partner at Sterling Lawyers. And today I have with me Senior Associate Cynthia Toscano. Thanks for joining us today, Cynthia.
Thank you for having me, Katie.
So, today for the podcast, we are going to be delving into business income and support and really what gets counted in Illinois or how that's calculated. So, for today, I want to just first start out, Cynthia, with asking you what kind of business income typically exists and how does that get included in support calculations in Illinois?
Absolutely. So, in terms of calculating child support and maintenance, the court must look at all sources of income, and that applies to everyone equally. So, when we're talking about business owners in particular, those sources of income can be one, more than one. There can be one source at a time. And two, they can vary from a typical W 2 or maybe even a self employed individual. But typically, the sources of income that we're looking at are salaries. A lot of times, owners of the business will incorporate their own salaries into the operating expenses of the business, distributions for LLC members or corporation members. And then another common source of income that we look at are what we call retained earnings, meaning earnings that they're sort of carrying over year for different financial and tax purposes. But all of that is still counted as income for purposes of determining if they have a maintenance and child support obligation.
And Cynthia, what do you specifically look to in order to kind of figure out what those amounts might be or if those things exist or are relevant in a given case?
Absolutely. I mean, in all cases, tax returns are incredibly important. So we are always going to reference tax returns in order to verify the income when we're running any sort of calculation. However, in cases where there's a business owner, they are particularly important because if it's a non business owner, 9 times out of 10, the W 2s will also help us. But when it comes to business owners, we can't just rely on the K1s or the 1099s or just those documents that their own companies produce to show what their income or their salary is. We really do have to comb through the tax returns line by line and really look at what deductions they're claiming. I always tell my clients what you can legally deduct on a tax return for purposes of what your tax bill is to the IRS does not equal what you can deduct from your income for purposes of maintenance and child support. There are always things that the IRS is going to say, yes, you can deduct that, and it's perfectly legal and you're not doing anything wrong, and great for you for saving on your taxes. But that does not mean that the judge is going to allow you to deduct that from your income. They are not held to the same standard, the same rules don't apply. In terms of judges, the statute is that they are allowed to deduct what are required and necessary expenses for the operation of a business. And required and necessary is not defined, but both parties can make their arguments what they consider a required and necessary expense. So obviously, if you're the business owner, you're going to want as many of those expenses to be listed as required and necessary. If you're the person that doesn't own the business that might potentially be receiving maintenance and child support, you really want to comb through and say, are those meals really necessary for him to run the business or for her to run the business? Is that depreciation on those assets really a necessary and required business expense? And you're going to try to look through those expenses and add back in as much as you can to what we call the pot of income, because the more deductions that you can sort of cancel out and add back in, the higher the income goes and the higher the maintenance and this child support obligation is going to go. So a lot of times we get clients that are very worried saying, I know he underreports his income, I know he does everything to avoid taxes, and that's all fine and dandy as long as it's within the bounds of the law, like people are allowed to do that. That does not mean that what they claim to the IRS as their income is the same thing that they're going to be able to claim to the judge as their income.
And so when you get a business owner that comes in as a client that you're representing, do you feel like there is a common disconnect with that individual in terms of like what they're able to deduct for tax purposes versus what a court is going to define as income for support purposes? And how do you message that to them in a way that makes sense? Because you want to bridge that gap.
Absolutely. I don't know if I would call it a disconnect, but there really is a conversation and sort of a realization period that normally has to happen with those business owners, because just like the, spouse that is not a business owner, they have the same impressions that what you report as your income to the IRS is the same thing you're going to be able to report to the judge as your income. And sort of having that heart to heart talk and sort of, walking them through the process that, unfortunately, while we wish it were that easy because it would make everyone's jobs a lot easier to just be able to submit that and call it a day, the judge is not bound by the same rules as the IRS. And at that point, you really do have to go through the tax returns with your client and come up with as many arguments as you can think of as to why those expenses are required and necessary. And a lot of times when you're having that discussion is sort of when I would say the realization period starts getting better, because then you're really able to connect with your client as to this is a necessary business expense, because if I didn't pay these legal fees, like I would not be able to legally run my business. If I didn't pay these marketing and advertising fees, like I could not get enough business to come in to sustain my business. So there are certain things like that the other side might be like, oh, you don't need to pay that attorney, you don't need to pay those marketing fees. But as you're having that conversation with your client and you're really digging into the details of their business and why it's necessary and required, you sort of gain a lot of insight into, how they run their business and what they believe is important and how they sort of structure the revenue of their business. And then
Yep.
during that conversation is really when kind of are able to feel slightly better about the fact that it's very likely that some of these deductions are going to end up coming back in.
Definitely. And then I feel like if, as an attorney, when you're representing maybe the non business owner, I always feel like the first step is printing off that schedule, going through it, highlighting or making notes as to, hey, this just seems off, or is this really legitimate? I think we should be adding this back in to make sure that we're properly defining what income is for support purposes.
Absolutely.
And then in terms of, business income in general, do you feel like a spouse actually can hide income through a business, or have you any direct experience with that? And what did you do as a result?
I mean, I feel like a lot of times people definitely try. So that's a fairly common situation where people attempt to hide income. And again, because they're relying a lot of times on, stories from third parties like family members, or maybe even conversations that they've had with their accountant or their CPA, they know what the law is in regards to, taxes, but they don't know what the law is in regards to dissolution proceedings. So a lot of times they can come in and they can be like, oh, well, my accountant said that if I did this on my taxes, then that's technically not income to me, and I don't have to do X, Y, and Z, or things like that, where they think that they can hide income. Although you can try, it's very, very difficult, because in order for you to try to hide income, a lot of times for you to be successful at hiding income, it's going to require you 9 times out of 10 to break a law or two, whether that's a tax law, whether that's a reporting law. In order for you to hide income, there's things that you have to do that you really can't be doing. And if you do those things, it's going to come to light. And dissolution of marriage proceedings are public record. They are public record, meaning that anything that gets put in a pleading, any testimony that gets said in open court is public record and can and will be used against you in potential criminal proceedings. So, in order to avoid the possibility altogether of facing some potential negative repercussions for doing things that you really shouldn't be doing, I always, always, always advise clients, don't engage in that behavior. One, because likely it could be criminal behavior, and two, operating in bad faith like that is not going to win you any points with the judge. You might win a small battle as part of the case, like you might get your maintenance and child support down from what you wanted it to be, but long term, when things like that come to light, and they do always come to light, once your credibility is damaged, it's nearly impossible to repair that with a judge. And having damaged credibility before a judge really is one of the what I call the nails in the coffin of a lot of cases.
Yep.
So for that and I tell, when I represent the spouse that's not trying to hide income, I tell them the same thing. In order for your spouse to hide this income, they're going to have to do things that they really shouldn't be doing, and for that reason, it's highly unlikely that it'll happen. But even if it does, there's paper trails, there's forensic accountants, there's evaluators, there's definitely experts that we can explore that'll help us get to the bottom of it.
Exactly. I could not agree more. And kind of leaning on those experts during cases to really get to the bottom of things to help either reassure your client or maybe at least give them better clarity as to what that would look like, I think is a really powerful thing. And like you said, to have an expert look into something, it's either going to unearth the fact that this is in fact happening, or maybe give them the reassurance that that's not happening, and then they can move forward with resolution. And let me ask this too, going back to the schedule and adding back these expenses. Based on your experience, Cynthia, I had this once in a case and I want to see if you've seen it as well. Sometimes with certain types of expenses, like let's say a vehicle or a cell phone, or if someone works out of their house, sometimes a certain percentage of that could be considered a legitimate expense, but maybe the remainder of it is not considered legitimate because a lot of these expenses are in fact personal and are being run through the business, or like a mix. Have you experienced that directly in a case?
I have experienced that directly, particularly in what we call more small businesses, which are becoming more and more common, or what, people nowadays call like side hustles or additional streams of income, where they're running sort of a small business out of their home. And it could be anything from, like having an Etsy shop or, baking, selling desserts out of their home, things of that nature, where there really is this sort of mix between the personal and the business. And again, that is becoming more and more common, as time goes on. So it's definitely come up in cases, and it's definitely something that needs to get explored in detail. So at that point, you're starting to have conversations with your client like, okay, how many days out of the week are they, using the cell phone, or are they using the home office for business versus, home? Like, is it they work from home 2 days out of the week? So 2 out of the 7 days, it's going to be used for business purposes, and 5 days can be used for personal. So you really start getting into the nitty gritty so that you can sort of separate out the percentages. And then also, a lot of times, to be completely honest, what we're sort of deciphering through are smaller expenses like the cell phone or like the internet or things like that. And a lot of times those deductions really aren't that large. Like your internet bill can only be so much, like $100 a month times 12 is 1,200, or
Yep.
your cell phone bill is, we're not talking about like tens of thousands of dollars here. So depending on how large the expense is, sometimes it's worth it to get into the percentage, and sometimes it's not really going to have enough of an impact on the maintenance or child support calculation to really warrant having to dig through it that deeply, if that makes sense.
What a great point in terms of that cost benefit analysis and making sure that it's actually worth it. And the impact on the support calculation makes sense because, like you said, if you're spending a ton of time on something and legal fees on something, you really want to make sure that you're getting a proper return from that. And that may not always be the case if there is such a small impact on the support amount that it may not necessarily be worth litigating or worth looking into, with a fine tooth comb. And Cynthia, based on your experience, have you ever had a case where maybe the income figure for a business owner kind of shocked them? And have you ever been on either side of a case like that?
Yes, one particular case comes to mind. It was a post judgment enforcement. I represented the obligee, so she had not been receiving the support she was supposed to be receiving for the minor children, and the obligor was a owner operator of a semi truck. So when you comb through his tax returns, there were a lot of expenses in there that were of course required and necessary, like gas. You clearly need gas to run a semi truck, things of that nature. But one of the things that can sometimes get dicey, and not just for truck owners, but for a variety of different businesses that have assets, is depreciation. So what you are allowed to claim for depreciation for certain assets can vary from year to year. Sometimes you're depending on, IRS regulations and what the asset is, you can front load it, you can space it out over the course of several years. It can vary significantly. So in this particular case, at the most recent tax returns we were looking, the obligor had claimed a significant amount of depreciation, like tens of thousands of dollars of depreciation on the value of a semi truck. And that had significantly impacted his earnings on his tax return, even though he had made well over six figures in gross receipts. So when it was time to come in on enforcement and they were making this argument about the depreciation being a required and necessary expense on a semi truck to depreciate tens of thousands of dollars in a single year, it really was an argument that the judge was looking at with a raised eyebrow. And, as I'm sure logic prevailed, and the judge was not buying it. And I really do think that the obligor really thought that he was going to be able to be successful on this argument and really be able to bring down what he was going to be required to pay, and it didn't work. So there's definitely situations like that where unfortunately people go in and their expectations have not been properly managed by the people that should be working with them to manage their expectations. And ultimately, it was a win for my client, but you never know what side of the coin you're going to be on. So you always have to make sure that you have a good enough relationship with your client, that they trust your judgment, that you know what the arguments are that you're going to make, and that you're able to properly manage their expectations and not sort of have them walk in with what could be unreasonable or false hopes.
Yep. It's almost better to have that open, upfront discussion with the client on the front end to just tell them what's realistic in those instances versus, having a situation like what you just described. And then have you ever, or do you feel, Cynthia, like sometimes there are businesses or business owners where income is unpredictable? And how is that handled in divorce cases?
Absolutely. Unpredictable business income is actually probably more common than not. No matter what the business is, you're never going to have the exact same amount of gross receipts or net income from month to month or year over year. Some sort subsets of businesses in particular, like self-employed individuals or things like that, it can be even more drastic in terms of the variability. There can also be extenuating circumstances that are out of people's control, like COVID, for example, like that threw everyone for a loop and affected everybody's business. So things like there's definitely it's very common for us to have to address issues of variability of income, and in that situation there's different methods that the court has sort of begun to implement to address it depending on the particular facts of a case. So a lot of times, for example, if the owner of the business is guaranteed a certain amount of income per month or per year, and then depending on how well the business does that year, they could be entitled to additional income. In that situation, what typically the court does is they'll calculate the support and maintenance obligations based on the guaranteed income, and then they'll also implement sort of what we call a percentage on any additional income that they can earn. So there's going to be a base obligation, and then this, for example, it could be 10% of any additional compensation that they earn as part of the business, or 15, or whatever the case is, depending on the particular facts of a case. So what we call true ups, and true ups are essentially where the court is going to make an order now of what the child support should be based on the most recent income now. However, there's the understanding that that's probably not going to stay consistent. So on a year to year basis, the parties are going to exchange financial information to see what the income was that was actually earned versus what was expected. And if there is a difference in that, earned versus expected, there's a way to do the calculation so that you can determine what should have been paid in child support based on what was actually earned as opposed to
Okay.
what was paid. And then you sort of just pay the difference. So, for example, the court orders $500 a month in child support, and then the next year you make more business income. And once you run the calculations, it comes out that you should have been paying 700 based on what you actually earned. Well, then that difference of what was paid versus what should have been paid then just gets paid out in a lump sum by a certain date every year. And that's just a repetitive process that happens. And
Yeah.
then the last thing is when it's really the most unpredictable. Certain businesses that really just are not always consistent, like online businesses or smaller businesses that are just starting up. In those situations, we do our best to take an average of what has happened to give us a more clear picture. So, for example, a lot of the first example that comes to mind to me for when we really have to look at averages are like seasonal businesses, like landscaping businesses or
Yep.
snow removal. Like, obviously, in those businesses, there's going to be certain months where the income is substantially higher than it is in other months. Not fair to just look at the last 3 to 6 months of income because depending on when you are with the year, that could have a significant impact on the child support and maintenance. And it's also not going to be really reflective of what that person's actual income is throughout the course of the year. So in situations like that, then we really do look at a more holistic long-term average in order to determine, okay, this is a seasonal business and we know that during these certain months the income is higher, but in the last 3 to 5 years it looks like they've averaged $150,000 in revenue over the past 5 years. So then that's the figure that the court sort of looks at. And then the one important thing that's also good to keep in mind is that these are always modifiable. So while we do our best to enter accurate and precise child support and maintenance orders, no court, no human being on the planet can predict with 100% certainty what's going to happen in the future. So for that reason, if there anytime there is any change, that's substantial that wasn't already accounted for when we were making the child support and maintenance determinations, allows you to come back to court in the future and ask for a modification. If your business gets bought out, if something outside of your control happens like COVID and that affects your business, if there's a hostile takeover, it could be a million different things that happen every day that people can't predict. And there's always sort of that safety net of knowing that, God forbid something happens, you always have the ability to go back and modify.
Absolutely. And in order to do that, someone would have to file a motion and get before the judge. You should never really just unilaterally choose to pay less, like, definitely go through the proper channels, right?
Absolutely. If you believe you might be entitled to a modification, the first thing you should do is consult an attorney. Always consult an attorney. Do not just take unilateral action. Do not engage in what we call self help, meaning that you sort of decide what the next best step is and just implement that without,
Yeah.
consulting or referring with a legal professional. Courts do not like when parties engage in self help. And a lot of times you could be making mistakes that you're not even aware of. So we've had situations where even, for example, they'd be like, oh well, I lost my business and I spoke to the other side and they were okay with me paying this modified less amount. And although that's really nice that the parties can get along that well to sort of reach that agreement, you should still always consult with a legal professional, because unfortunately, even if it's done quote unquote by agreement, agreements can change over time. And just because you and the opposing party agree to something doesn't mean that the court is going to uphold that agreement. So it can have a whole host of different implications. So for that reason, even though there is that safety net of a modification, if you believe that that's something that you want to explore or that you might be entitled to, that's great. But the first thing you should do is consult a legal professional.
I totally agree with you. And then let me ask you this, Cynthia, based on your experience as an attorney, you know, if there actually is a decline in terms of business performance or business income and you represent the business owner, how do you go about proving that that is in fact legitimate and that is something that's actually happening? Because that may be viewed skeptically by a judge or the opposing counsel who's representing the non-business owner.
Absolutely. I always tell my clients, if it is a legitimate decline, there is going to be a way to prove it. If it's something outside of your control, for example, a law that was passed that affected your ability to run the business, well, obviously, evidence of the law and how it impacts your business can be presented. There's experts that can be retained that can do an analysis as to how the passage of that law affected your business. If there is, closures like happened in COVID, obviously there's evidence that we can show to demonstrate how having to physically close down your business for X amount of days or months impacted your ability to bring in a revenue. If there was a hostile takeover, like whatever the legitimate decline is, there is going to be a paper trail, because we live in the United States and everything needs to be documented for the government. So we take the paper trail of whatever happened. Sometimes we'll need to bring in an expert so that the experts can sort of analyze and sort of interpret that paper trail and make it as easy to digest for the judge as possible. So sometimes we'll need to bring in experts, but as long as it is a legitimate decline, there is going to be some paper trail to allow us to do our best to prove it and argue it before the judge.
And then, as kind of a closing question for you, Cynthia, if you are representing or talking to maybe the non business owner spouse who is really kind of concerned, the numbers are not adding up, how would you best advise them to move forward? Or what steps would you tell them to take in that instance?
Absolutely. What I always tell people who find themselves in that situation is pay attention. Pay attention to everything around you, because a lot of times, unfortunately, when everything is good, you trust your spouse, you don't really feel the need to pay attention. You're just happy that everything is going great. That's great. That's amazing. I hope that happens for everyone. But, unfortunately, nothing is permanent and things can change over time. And then I'll have someone that walks into my office and says, the business was doing great and now supposedly it's not, but I have no idea what's going on. And in that scenario, it puts us in a little bit of a more difficult position in terms of a starting point of how we get to the bottom of what's happening to the business. However,
Yep.
if you've been paying attention, and I'm not saying you need to know like the profit and loss of every month for the business. I'm not saying you need to know the business like the back of your hand. That's not it either. But if you pay attention a little and you figure out, okay, well, I know he has his bank accounts at this bank, and I know that he's been talking to this CPA every other month, and I've noticed this calendar entry on his calendar for this business advisor, things like that, it really puts us in a better position in terms of starting point so that we are able to sort of direct our efforts and make them the most efficient as possible. Because if we know where the bank accounts are held, we can issue the subpoena. If we know who the CPA is, we can subpoena them as well, or we can take their deposition. If you have some sort of understanding of how the business works, or even where certain things are located or who the important people are, then that makes our job as attorneys that much easier in terms of getting that information and doing the best possible argument that we can make for the judge based on that information we were able to get.
So true, Cynthia. Thank you so much for joining me today on Family Law Insider and really just talking through business income, how we calculate it, and what impact that may have on support. And we appreciate you coming, and thanks so much, Cynthia.
Thank you so much, Katie.
Business income issues are complicated, but what about emotional evidence? That's where custody cases often take a turn. So before you rely on therapy records to make your case or defend against them, make sure you're not walking into the number one mistake that Illinois parents make.